Hello everyone, good evening, can you all hear me? Hello, good evening, can you all hear me?
Good evening.
All right, thank you, Mr. for confirming. Thank you so much for joining in to class. Please, I would want to, before we start the session, I want to encourage us, the mentees that are in class. Please, let's kindly do well to reach out to our co-mentees to let them know that class has started. We are all welcome to class and we are going to be picking up with this session as soon as possible. So please let us reach out to our commentators to make sure we have a full class. Thank you everyone. So we'll just give 1 minute for everyone to join or for more people to join and then we will officially start. All right. So while we wait for everyone to join in, we'll just kindly go ahead and introduce, I'll just kindly go ahead and introduce to this week's program. Welcome to the GC Mentorship and Internship Program under the ADR course. This course is brought to you in collaboration with the Settlement House ADR Training Institute by Shati, and we are currently in our week two of our GC Mentorship and Internship Program. It is funny how time can really go by real fast. Before we do it, it's going to be week three, week four, week five. Week three, week four, week five, and we'll be drawing closer to the end of the program. But while we are here, I really want us to take advantage of what we'll be learning in today's session. Yes, I really want us to take advantage of what we'll be learning in today's session. So in today's session, we'll be discussing mediation and career opportunities in mediation. And before, like we usually do, we'll introduce our mentors. After introducing the mentors, then we would go to mentees presentation. So please, for the mentees, let's try to make sure that we have contacted our group presenters and they are ready to present in class. After we're done with mentees presentation, then our mentors will get to speak. My name is Dennis Williams and I'll be moderating today's session. And Mr. Nyacham has asked that he wants to introduce the mentors himself. Thank you so much, Mr. Nyacham, for joining. So I will be handing the floor over to you for the mentors introduction. You're welcome, sir. Mr. Nyacham, are you with us?
Yes,
Please
please.
come.
Good day.
All right, sir. So let me go ahead and share my screen again and bring up the mentors flyers.
All right. So,
Hello, sir. Sorry, we can't hear you. Your network is a bit bad.
Mr. Can you hear me, Mr. Dennis?
Yes, I can hear you now, sir.
Okay, let us also take advantage of the light before um before after the mentor's introduction. We can just take our group pictures.
All right, sir, we'll do that, sir. Oh, okay. It seems Mr. Nyacham is having some problems from his end. So I will just go ahead to introduce our mentors while I wait for him to come back on the call. And when he's back on the call, then he would continue from anywhere I stop. Okay, Mr. Nyacham, are you with us?
Thank you very much. Thank you so much, Mr. Dennis, for always being there. We really appreciate you for all the good works that you have been doing. I can see that some of our mentors are already in. Today, we are going to be introduced. I'm going to be introducing the mentors. Uh, for some of you, you have already known me. My name is Nancha Nangwang, and I am the Executive Director of Settlement House ADR Training Institute. It is an institution for the training and certification of ADR practitioners in Nigeria and the world at large. We train and certify mediators, arbitrators, negotiators, among others. I'm a lawyer. I practice law under the law firm of N. Nanchan and Co., which is based in Kaduna State, Nigeria. I am a trainer and facilitator, as well as a teacher. I'm married to a female wife, and I'm blessed with children. That is just some of the things you need to know about myself. Okay. Next is Mrs. Nanchan Janet. Mrs. Nanchan Janet has been she is a mediator and a journalist by training. She is an international mediator. She's a teacher as well as uh, a secretary in a law firm. She has worked with lawyers for over 15 years thereabout, and then she has gathered experiences in different areas uh, of life. Ms. Janet is the current secretary of the Governing Council of Settlement House ADR Training Institute. And she is also a faculty member of Settlement House ADR Training Institute, among others. She is a listed neutral in the Kaduna State Multi-Document House. All right, so is next is our very own Miss Pa Free Awason. Miss Pa is actually a lawyer and presently pursuing a doctorate fellowship. She's currently pursuing a doctorate program for her PhD. She has over 20 years of cross-border experience in different areas of life. She is very, very passionate about alternative dispute resolution, ranging from mediation, uh, arbitration, among others. She is actually, I think, the center coordinator presently of the uh, the Rwanda branch of the Chartered Institute of Arbitrators. You can identify her by her passion for alternative dispute resolution, which accounted for how fast She rose from the from the scratch. She started her training sometimes in 2000 and 2021 or thereabout between 2021 and 2023, and then she has now rose to the point of being a fellow of the Institute of Chartered Arbitrators, United Kingdom. Thank you so much, Mispa, for joining us. Next, okay, so next is our very own Mr. Achidabara. Achidabara is a scientist. For some of you who think that the practice of alternative dispute resolution is reserved for lawyers or those within that area, I will be happy to tell you that one of the mentors uh, he is a teacher by training, an associate of Settlement House Area Training Institute, and a biochemist by training. So he has a science background, and he is a registered teacher with the Teachers Registration Council of Nigeria. He lectures postgraduate students both at Greenfield University as well as the program that Shati runs for NCE, that's Nigerian Certificate of Education, and the Professional Diploma in Education for those who want to acquire professional teaching qualification. So that is what we need to know about Achidabara. And today we also have with us a distinguished mentor, Mr. Stephen Mbayani Lungu. He is a state council of Zambia. Just for you to understand, when you say chief counsel is equivalent to a senior advocate of Nigeria, in Zambia. He, he is someone that you will want to tap from his experience, ranging from the banking sector to partnership and law firms, to taking master's degrees in international law and banking, as far back as in 1975, to taking a diploma in leadership and sustainable development from the University of Columbia in 2024. He has also taken part in the training of ADR practitioners, having undergone a training of trainers himself, to be able to pass across the message, and preach the gospel of ADR. He is someone that I know that you are going to enjoy listening to because of his passion. He has risen at the professional cadre or level. He has risen to the highest level of legal practice, which is becoming a senior advocate, of Zambia. They call them state council, and he wears the silk. Uh, his profiles actually reflect not only professional distinction, but also a sustained commitment to strengthening mediation practice and developing the next generation of dispute resolution practitioners across Africa and beyond. Thank you so much, Leonard Silk, Stephen Lungu, for joining us. Next is one of the youngest mentors in the house. She is Queen Esther Ozioma Emmanuel. Queen Esther is the certified mediator with Settlement House Area Training Institute, uh, having been trained and inducted, as a mediator. She is an associate of Settlement House Area Training Institute, and she is so passionate about uh, alternative dispute resolution. Among several other things, you can see an expression of passion in trying to ensure that justice is done not only in the school or education environment, but among other professional organizations or bodies. She currently serves uh, as the executive assistant to the executive director of Settlement House Area Training Institute, where she plays uh, a strategic role in execution of administrative, institutional, and coordination among several others. She is presently the International Federation of Female Lawyer Chairperson of the ABU branch, ABU Zaria branch, where she contributes to the advancement of women rights, legal awareness, among other things. She, she is so passionate about alternative dispute resolution, making her to actually come and do her internship under Settlement House Area Training Institute, where she has learned to take part in some practical mediation sessions, where she adds up to her theoretical experience. Um, just a moment, let me share from this. And yeah. So, okay, so the next person we are going to be looking at, please confirm if you can see my screen. Kindly confirm if you can see my
Yes,
screen.
we can.
Yes,
All
I
right,
can
thank
see
you.
it.
All right, so the next mentor we are going to be introducing is His Honor, Honorable Joshua Azaka Inyam. Honorable Joshua Azaka Inyam is a proud associate and certified mediator with Settlement House Area Training Institute. He also sits as the upper area court, upper customary court judge in Kaduna State Zaria, particularly. His passion for justice being done made him to enroll to become a mediator as well as an arbitrator. He's currently a certified and chartered arbitrator with the Nigerian Institute of Chartered Arbitrators, and he has recently been trained to join the faculty as a faculty member of the Nigerian Institute of Chartered Arbitrators, where he is going to be contributing his knowledge and understanding to those who aspire to become ADR practitioners, particularly mediators. Uh, he, in addition to his legal and ADR credential, he is a certified trauma healing specialist, an expert that enriches his approach to dispute resolution by incorporating sensitivity to psychological and emotional dimensions of conflict. His holistic perspective strengthens the ability to guide others in managing complex and sensitive disputes with empathy, neutrality, and protection. If with professionality, one thing that you want to know about him is in respect of his passion for ADR is his ability to volunteer. He volunteers his time, his resources, to mediate between matters, at the Kaduna State Multi-Law Court House, as well as other ADR related activities. We are happy to have you, uh, Mr. Mr. Honorable Joshua Zakanyam. Thank you so much for joining us today. Next, now we are going to be having is is Mr. Isaac Asare. Mr. Isaac Asare is one of the uh, humble and uh, professional I've ever met, very passionate about the promotion of alternative dispute resolution in Ghana, Nigeria, and Africa at large. That actually made him to push for the establishment of the Africa Center for Collaborative Dispute Resolution in Ghana, and where he serves as the president and founder. Among other things, he is very, very passionate about preaching the gospel of alternative dispute resolution and making alternative dispute resolution one of the preferred means of settlement of disputes in uh, Ghana, Nigeria, Africa at large. And he wants, it is his vision to see that Africa begin to become the hope for alternative dispute resolution, where we can begin to have regulations, we can begin to have practice appointments within Africans for that purpose, and that is actually what he's doing. He also, the Africa Center for Collaborative Dispute Resolution trains and certifies mediators, arbitrators, as well as paralegals. That is Isaac for you. He is my president, and I'm honored and privileged to have him join here as a mentor to contribute to knowledge. Thank you so much, Mr. President, for joining us. Uh, Having said this, I think basically uh, we have introduced. Oh, yes. Okay, so the last but not the least, if I'm not mistaken, is my very good friend, Deborah Maida Maigari, DMM, so to say. Uh, she is someone who is very, very passionate about whatsoever she does. She is a teacher of the English language with the Kaduna State Ministry of Education, and she is a dynamic and multifaceted professional whose work spans from mediation to leadership development to education to faith-based services, entrepreneurship, strategic communication, among several other things. She brings a holistic and people-centered approach to conflict resolution, grounded in empathy, emotional intelligence, and principle engagement. Having trained as a trauma healing coach, that has actually added to our further, other things that other qualities that will make her better mediator. And she's so passionate. She's someone who always volunteers and make herself available to help resolve disputes and conflicts, wherever they are, and she's called upon. She's very passionate about contributing to the next generation of alternative dispute resolution practitioners, and that is why she has volunteered her time and her resources for the purpose of mentoring the next generation of mediators and ABR practitioners in the making. Thank you very much, Deborah Maida, for joining us. I think there is one of my good friends that I have not yet introduced, and that should be, yes, yes, uh, my friend Khadija Kabir Shehu. She is a lawyer by training and she works with the Kaduna State Multi-Law Court House. She is a full member of the Institute of Chartered Mediators and Conciliators. She is a dedicated legal practitioner and an experienced mediator with over 8 years professional practice in mediation. She currently serves as a mediator with the Kaduna State Multi-Law Court House, where she plays important role in facilitating amicable. Can you confirm if you can hear me?
We can hear you, sir.
Yes, Khadija obtains, her law degree from Bayero University, after which she was called to the bar in 2015, and since then she has been contributing immensely to alternative dispute resolution and justice generally. Khadija remains committed to contributing positively to the legal profession and to helping individuals and organizations resolve dispute efficiently. Due to her passion for alternative dispute resolution and institution, she has enrolled and has been trained to become a mediation trainer with the Mediation Training Institute and now serves as one of the faculty member. Thank you so much, Khadija, for joining us. We believe that we are going to be having a very interesting moment uh, together. Thank you very much, Mr. for the opportunity to introduce the mentors. So please over to you so that we can go ahead. So may I crave your indulgence to possibly have your, I think it will be a good time to take our group pictures, or should we leave it to maybe 7 o'clock?
All right, I think it's going to be fine. We take the pictures now. I would want to encourage all our mentees while we are taking pictures. Please, presenters, let's get ready for presentation because we'll be taking your presentation immediately we are done. We are done with our pictures. So please, if you can, right, turn on your videos. Let's quickly take pictures for class, and then we'll be sending it over to you after the class. So please, let's take pictures. Turn on your videos. Let's quickly take pictures. Thank you, everyone. Let's quickly turn on our videos. Thank you very much to our mentors that are turning on their videos. Mentees, please let's turn on our videos. Okay. I'm still waiting for us to turn on our videos in mass so that I can take a one-time picture. Right, let's do that. Thank you. All right. I can see we have a handful of people who have, so I'll be doing that now.
If you connect with a system, you can as well take a picture so that it will encompass all of us. I'm trying to take one here with all of us inclusive. Okay, just a minute.
All right, so for my end, I'm done taking the pictures. Thank you,
Okay,
everyone.
just a minute. Just a
Okay.
minute. Just a minute. Um, uh-huh. Just a minute. I can see all the beautiful faces. Wow. Ha. Wow. Thank you so much, Mr. Stephen Lungu, for joining us. We do not take your presence for granted. Please, others, please put on your cameras, please, so that all of us will be captured. I would love to have all of us. Good. Wow. Thank you so much, Leonard, for joining us. Wow. I can see so some of us are not reflected. Yes. Okay. Let me see. Good. Aha. Good. Thank you. All right. So we are good. Thank you, Leonard, for joining us. We are happy to have you. All right. So it's expected that the mentees will make their presentations. We have also shared their slides. The mentors will take note of their presentation and then make necessary contributions to what they have done, make corrections, make inputs where necessary. Thank you so much.
All right, thank you very much, Ms. Sonia Cham, for helping us also coordinate pictures. So please, for the mentees, like we earlier said, we are taking presentations right about now. So please, let's get ready for presentations. Presentation time is 10 minutes each. All right, so please, let's try as much as we can to stick to the 10 minutes time frame. I don't think we have our group one presenter yet here on the call. So please, we'll be starting with group two while group one gets ready. So group two presenter, if you're ready, you can go ahead, you can share your screen and then start your presentation.
Okay, I'm going to share my screen now. Please, can you all see my screen?
Yes, you can see your screen.
Yes, we can.
Okay. Good day, everybody. My name is Oluwafunmilayo Adekoya, and I'm presenting for Group 2. We are presenting on the drafting and practical exercises in alternative dispute resolution. So, the presentation is structured into 4 main areas. First, we are going to examine how to draft terms of settlement. Next, we'll discuss the relevance of and the draft of an ADR clause. Then discuss the procedure for and the agreement to mediate. Finally, we'll discuss how to resolve deadlock in mediation. Now, before we look at the draft, it is important to understand what terms of settlement actually are. In the context of ADR, terms of settlement are the written agreements that are reached by disputing parties. They are documents that outlines the specific obligations each party agrees to fulfill to resolve their dispute. And the most critical legal feature of this document is that once it is signed, it can be filed in court and enforced as a court judgment. Now let's look at the sample draft involving a dispute between Mr. Chinedu Okafor, who is the claimant, and Mr. Tunde Adebayo, who is the respondent. First, we have the introduction. Which states that the terms of settlement are made on the 9th of March 2026, following a mediation at the Lagos Multi-Door Conference. Then from the introduction, we have the background, which involves a supply of 50 bags of rice valued at 850,000 naira, and the respondent failed to pay. Both parties resolved to both parties agreed rather to resolve the dispute through alternative dispute resolution. Then we have the terms that was agreed by the parties, and the terms agreed by the parties to a payment of the outstanding debt is through installments, and upon full payment, the claimant will withdraw all claims. It also includes clauses on confidentiality and enforcement. Lastly, the agreement has a binding offer and it is signed by both parties and also the mediator. Now, we have the relevance of ADR clause. An ADR, or you can say a mediation clause, is a proactive tool that requires parties to a contract to attempt mediation before they move towards arbitration or litigation. And during this process, a neutral third party, who is usually the mediator, facilitates the communication. And the mediator does not impose a decision, but rather he helps the parties to reach their own mutually acceptable settlement. Here we have drafted 2 types of clauses for consideration. The first clause is a multi-tier clause, stating that any dispute must first be referred to mediation at the Lagos Multi-Door Courthouse under the Arbitration and Mediation Act 2023. And if it isn't resolved in 30 days, it moves to arbitration. While the second clause emphasizes on negotiation first, and if negotiation fails, they move to mediation within 30 days. If the parties can't agree on a mediator, an appropriate authority will appoint one, ensuring the process remains confidential. Now, why should these clauses be included? Why should we include mediation clauses? And there are 4 primary reasons why mediation clauses should be included. The first is that it is cost efficient. Mediation is less expensive than litigation because there are fewer legal procedures and administrative costs. Then we also have confidentiality. Confidentiality in the sense that the proceedings are private and it protects sensitive business information, and also the reputation of the parties. Then it preserves relationships. It encourages cooperation rather than confrontation, and this is vital for maintaining ongoing relationships, for example, business partnerships. Lastly, it is flexible in the sense that it allows for creative solutions that a court might not provide, giving the parties control over the outcome of the mediation. Next, we have the agreement to mediate. The agreement to mediate is a written document where the parties formally submit their current disputes to the mediation process, and it is recognized under the Arbitration and Mediation Act 2023 as a formal dispute resolution mechanism in Nigeria. Section 67 of the Act requires that parties to a mediation agree in writing. The process typically begins with a written proposal, which the other party has 30 days to accept. Now, it is important to note that mediation proceedings are confidential, and the statements made cannot be used in court. Any resulting settlement must be written, signed, and then it becomes binding and enforceable as a consent judgment once that's decided by both parties and the mediator. Here we have a sample draft dated the 9th of March 2026. In this sample draft, we established the framework of an agreement to mediate, and we started with the identification of the parties. The agreement here is between Mr. John Mark of number 5 Eco Street, Abuja, and Mr. Smith Uju of number 8 Jimmy Street, Abuja. Now, under the first section, we have the purpose of the agreement, where the parties explicitly agree to submit their dispute to mediation according to the Arbitration and Mediation Act 2023. The second section deals with the appointment of a mediator, and this section allows parties to appoint a specific mediator and provides the appointments, and also provides for the appointment of another mediator in case that mediator is unable to act. And then we have the role of the mediator, which provides that the mediator is a neutral facilitator that helps the party to reach a settlement. The fourth section is the conduct of mediation, and here the parties agree on the procedure, or they allow the mediator to determine the process for the mediation according to the Arbitration and Mediation Act. Then we have confidentiality. Under confidentiality, it's important to know that all statements and documents used in the mediation process must remain private. Continuing with the draft, the 7th part covers the settlement agreement, and this is the most crucial outcome of a successful mediation. According to the Arbitration and Mediation Act, if the parties reach a resolution, it cannot just be a verbal agreement. First, it must be reduced to writing. Second, it must be signed by all parties involved. Third, and once these steps are taken, the agreement becomes legally binding and enforceable under the Act. Then we have termination and costs. The mediation ends once a termination is reached, or if the mediator declares it unsuccessful. And then the cost of mediation, which includes the mediator's fees, are shared equally by the parties unless they agree otherwise. Then we have the governing law, that is the law that's going to govern the mediation process, which is the laws of the Federal Republic of Nigeria, particularly the Arbitration and Mediation Act 2023. Then the signatures of both parties and the mediator. The last part deals with resolving deadlocks in mediation. Now, deadlocks refers to situations where parties reach a particular point where they cannot agree, where the parties are not like agreeing on the matter. So to break this deadlock, mediators use four main strategies. The first strategy is mediators use private meetings and reframing. This is where the mediator speaks to each party individually to find their underlying interest instead of their rigid positions. Then we have the second one, which is the mediators, which is the objective standards, which is the use of objective standards. And in this, under this strategy, when the parties disagree on what is fair, they look at the external or neutral facts like laws, norms, or even expert opinions. For example, if there is a matter between regards the price of a particular car, and let's say a party is saying that the car costs 10 million naira, the mediator can suggest the mediator can suggest looking at an official dealership price or this is or a standard car valuation price guide to determine the actual value of that car. So this is going to move their focus from the opinions of the party to the facts itself. Then third, we have creative solutions and break. Mediators propose creative solutions and breaks when this is like to reduce tension and encourage cooperation among the parties. For example, let's say the mediation process has been going on for 6 hours straight and the parties are probably tired or even angry. So the mediator can propose a short break, probably a 15-minute break, to help the parties reset and come back with a calmer perspective. And the last one is managing emotions and communication. Mediators use techniques like paraphrasing and open-ended questions to help parties understand each other. Thank you very much.
All right, thank you very much. Sorry, I didn't get again who was presenting. Oh, Fumilayo. Thank you, Fumilayo, for your wonderful presentation. Well done to you and to your team for putting it together. All right, we'll be getting back to the feedback where our mentors will be giving feedback to the presentation while they are taking the discourse on the topic for today. But before we do that, I want to find out if our presenter for Group 1 is available. We'll be taking your presentation now, so please let's get to it so that we do not waste any further time. Oluwafumilayo, please you can stop sharing your screen. Hello, can we hear me? Hello, can we all hear me? Please, can we confirm that we can hear me?
Yes, sir, I can hear you.
Oh, all right. So please, Group 1 presenter, if you're with us, let's get straight to your presentation. If you need help sharing your slides, we can help share the slides on your behalf. If the presenter is not available, we can have someone step in on behalf of the presenter to take the presentation. But let's try and get straight to it. Thank you.
Okay, so can we have the group members of group one? Please, can you indicate group one? Do we have any member of group one here? All right. So
Some
I
people
can
are
see,
facing.
yes, I can see about 1, 2, 3. All right. So do we have a backup presenter here? Or
Backup
anyone
presenter is
among
not
you?
available.
Okay, so any one of you can just make the presentation. Remember, we are all learning. So you do what you can, and then we are going to go into the main mentorship session where we are going to be giving our contributions as well as attending to your questions. So please, we need someone to share. Okay. So Olamide, are you going to be sharing for us? Kindly help share the slide. Olamide, if you are indicating, please go ahead. I can. Okay, Olamide, please go ahead. Can you share the slide by yourself? If you can, please go ahead.
No, sir, I'm going to need help. Can you please help me share the slide?
All right, I'll do that
Okay.
now. So just kindly
All right.
introduce yourself while I do that for you. Can you see my screen?
Yes, sir.
Yes, so please go ahead. Just let me know when you want to move to the next slide.
Okay, sir, please can you go to the next slide? Okay, good morning, good evening, everyone. I'm going to be talking about mediation and career opportunities in mediation. And please, the next slide. So mediation is also a form of alternative dispute resolution, and it is where basically a neutral third party that is called the mediation is going to help those parties, the conflicting parties resolve their disputes. And the aim and goal of mediation is to allow the party reach a compromise or reach a satisfactory conclusion where both of them would have a satisfied result on their issues. So it is generally non-binding unless the parties sign settlement agreement. As the last speaker said when presenting, this settlement agreement is binding, and once they reach this when they sign this settlement agreement and it is drafted and signed, it is binding and can be enforced in court. So mediation, one of the major advantages of mediation is that it is less expensive than litigation and it is faster with confidentiality and due to the principles of mediation, which are good to see in the subsequent slides. Please, can you the next slide, sir? So the first thing we're going to be looking at is career opportunities in mediation, and we've had like their mediation has become increasingly important method of resolving dispute outside of the courtroom, and because of this, it has created several career opportunities where individuals are trained in different aspects of dispute resolution, and one of these main opportunities is court appointed mediator. A court appointed mediator is basically a person that the court trained mediators where they are allowed to what to help parties resolve disputes to reduce delay. Please, the next slide. To reduce delay, we have family mediators. These are people who work with sorry, please go back. These are people who work with family mediation. These are people who work with family, usually when there's an issue with this divorce, custody, and custody, child arrangement, and stuff like that. Family mediators, workplace and employment mediation, where there are employment disputes. Usually, this is becoming increasingly popular, where HR company integrate mediators and alternative dispute resolution into their human resources, where instead of having this formalized and difficult way of resolving disputes, they just integrate mediation into their workplace resolution. We have commercial and business mediation, which is actually very important because one of the advantages of mediation is to allow each party to be able to foster their relationship, that they can still continue their relationship. Because when you say that in online in litigation, it is usually there's usually a winner and there's a loser, some with an advantage and some with a disadvantage. So there's this difficulty with them continuing in their commercial relationship, and commercial and business mediation. This is where a person will be trained. The mediator is actually trained in this aspect where they deal with business and commercial disputes. And now it's community mediation and online and virtual mediation. And these are people who actually mediate from remote locations. This is what they do. Insurance mediation and mediation training and education. These are people who actually train mediators. So this is another career opportunity to mediation. Please, next slide. So there are different principles governing mediation. We have voluntariness, neutrality, confidentiality, self-determination, and good participation. One of the major principles of mediation is voluntariness. That means the parties must be willing to actually mediate. Before you I'm sorry, I got disconnected. So please, can you hear me? Can you hear me?
Yes, we can hear you now.
Yes, we can hear you.
Okay. So one of the principles of mediation is voluntariness, neutrality, confidentiality, self-determination. Voluntariness is very important because each party must have mutually agreed that they are willing to mediate and settle their disputes informally.
Um, okay, Olamide, are you back with us?
Yes, so I got disconnected again. I'm sorry, sir.
Yeah, sorry. Yeah, please go ahead and continue.
Okay. Okay, I said each parties must have agreed that they are willing to mediate and settle their disputes informally. And usually business transaction, they always have an agreement that, okay, fine, once we're in conflict, we are going to resolve our dispute in one way or another. And so one of the fundamental principles is that they must be willing to participate in mediation process. And it should be noted that during this voluntariness also connotes that they are able to withdraw at any time before they are able to like sign the settlement agreement. That is, they can participate in the mediation process willingly, and they are also allowed to withdraw at any time before they sign the settlement agreement. And also confidentiality, which means that information shared during this process is usually private. There's something called there's this process when in mediation where the mediator is going to talk to each party differently. And one of the principles of mediation is that the mediator must ensure that nothing discussed, even when the parties are put in separate different positions, where they're allowed to share their issues, it should remain confidential, even despite the fact that it's the same issues, where parties raise different issues in different settings. The mediator must make sure that it is confidential. So the mediator must remain neutral. Of course, this doesn't mean that it is hard for people to remain neutral in position, because one of the reasons a mediator must be actively involved in the issue. So this does not mean that the mediator cannot be might not share feelings or have this familiar feeling with a particular side, but it must ensure that his feeling does not with the outcome of the mediation process. It must not be openly biased to one party against another. It must be neutral, and it must not take essentially but not make sure it must not allow its bias to reflect in the decisions. Another one is self-determination, which means that they are able to control the outcome of the mediation. And one of the process of mediation is negotiation, which means that parties are allowed to actually raise a compromise, raise their issues, offer problems. In mediation process, there's a process where they will be allowed to actually become creative with their solutions. How can one reach this particular decision? And this is one of the main essential features of self-determination as a principle. They are able to come up with creative solutions, reach a compromise in a way that will benefit each other, foster their relationship. And another one is good faith participation. Of course, there are other principles of mediation. Of course, there are other principles of mediation that goes beyond this one that we're looking at. There's impartiality, which is also an extension of neutrality. There's impartiality, also an extension of neutrality, and there's also there are other processes of mediation that is beyond this one that we're looking at. And then we're moving to the stages and process of mediation. Please, at the next slide. Okay, so we have the premeditation process, which is the preparation and the appointment of the mediators, and we have the mediation process, which is discussion and negotiation, and we have post-mediation process, which is settlement of disputes and the agreement or continuation of the dispute. So in mediation process, you are going to appoint a mediator. Usually, mediators are usually appointed by an agreement, so the parties will actually make an agreement that okay, they want to appoint this person to be their. So I keep disconnected, so I'm going to just run through it. We have the pre-mediation process. This process is also like where the opening stage, where they pick their mediator, and where they prepare for the mediation process. The discussion and negotiation stage, usually this process actually takes where the mediator facilitates the discussion between the parties. They explore possible solutions, and sometimes the mediator might actually hold private meetings with each parties, known as courses or something, where each party actually raise their own issues in private meetings. And also we discussed that it is essential that during this process the mediator remains confidential, that even despite the fact that they are the same parties in this, that they are parties in the same issue, this does not absolve the mediator of the duty of confidentiality. And then we also have the we have the mediation process, negotiation, and then post-mediation process. The parties either settle or they continue their disputes, and they can continue their disputes perhaps in the court of law. And it should be noted that there's actually this duty on mediator, that the fact that you like issues are raised up is not in every issue that you are all those issues that are raised. That does not mean that the mediator during a court proceeding where they choose litigation, they can actually disclose those issues. They can't. And then we have the agreement stage. Here the mediator help draft the settlement and the agreement, and then if they go ahead to sign, it becomes binding. Please, the next slide. And then we have the agreement to mediate. This is a written or oral agreement between disputes in which they voluntarily submit their disputes to mediation with the assistance of the mediator. And it may arise in two main ways: the pre-dispute mediation clause and the post-dispute mediation clause. Okay. My article contained a different. So the agreement to mediate is basically a formal understanding between the parties where they attempt to resolve their dispute through mediation before going to court. And this agreement may exist as a clause in the contract, or it may be signed after a dispute arises. Usually in the commercial agreement, they have a contract where once they have a provision that once a dispute arises, they have to solve it in a particular way. So this agreement usually outlines the important aspects such as the appointment of the mediator, the confidentiality obligations, and the voluntary nature of the process. And the significance of this agreement basically is that it actually allows for this amicable resolution of the dispute. It reduces litigation costs, promotes personal and business relationship, and the court actually encourages parties to actually enter into agreements to mediate before proceeding with litigation. And then the next one is the terms of settlement. Please, the next slide. Okay, I've talked about the significance of the agreement to mediate. It establishes the consent of the parties, provides structures for the mediation process, it protects confidentiality and costs, encourages dispute resolution, it preserves relationship and reduces cost congestion. With how alternative dispute resolution is growing, the court actually prefers, like, where they feel that this issue can be resolved amicably, they actually encourage the parties to go to choose mediation process instead. So another one is terms of settlement. A legally binding written agreement that records the final resolution reached in mediation, and it includes the identification of parties, the introductory section, recital of fact and backgrounds, terms of settlement, the payment terms if there is any, list of claims, confidentiality, and non-disclosure clause. So the terms of settlement is basically the final agreement that the parties have reached at the end of the mediation process. This is basically the result of this is basically the result of the mediation process. So these terms clearly state the obligation of each party, the steps they are required to take to resolve the dispute. For example, where the mediation agreement involves the payment of compensation, for example, maybe doing employment and stuff, or the fulfillment of any other obligation arising from contract or result of claim. So the settlement usually always show a clear timeline, like once which particular time will this person fulfill this particular obligation, which particular time will this take this action in fulfillment of the terms of the settlement, and then it also contains the confidentiality provisions. And once the parties sign this settlement, these terms of settlement, it becomes legally binding, particularly if it's filed in a court or incorporated in a consent judgment. And the settlement agreement represents a successful outcome of a mediation. If a mediation is not successful, then parties may go on ahead to for a formal litigation process. Please, next slide. So I think the conclusion is that mediation is an effective method of dispute resolution. It promotes communication and cooperation. It offers various career opportunities, and proper mediation process help parties achieve efficient, peaceful learning for a stronger relationship and stuff like that. And that's the end of this presentation. So.
All right, thank you, Olamide, for stepping in to present on behalf of your team. Well done to you for stepping up to take charge of the presentation. Well done to your team members that put it, including yourself, that puts the presentation together. Please, we want to encourage mentees that this is a collaborative work from your end. Please, let's make sure that we are well familiar with everything that is in the presentation, so that in the instance where the main presenter or the backup presenter is not available to make presentation in class, like Olamide did, we can have people who can step into the shoes of the presenter and present on behalf of the team. This is a learning platform. This is more of an academic internship, and you are expected to carry out with every task and make sure that you fulfill the obligations of your group and your team. So thank you very much once again, Pupon and Olamide, the presenter. So we'll be heading into the discourse. Our mentors have sat down. They've had the presentations from the mentees. They've had the opportunity to go through your slides. So we want to give them the opportunity to share their thoughts and contributions on the topic for today. That's firstly the topic for today, which is mediation and the career opportunities in mediation, and then give feedback to the presentation. So I'll be handing over to Mr. Nyancham, who will be handling this session. So Mr. Nyancham, over to you, sir.
Thank you to the mentees for what they have done thus far. We also appreciate Group 1 and the backup presenter, or the lady that stepped in to help in the presentation. We are very grateful. So this week we are looking at mediation and career opportunities in mediation. That's the subject of what we are discussing. And where necessary, I'm going to start first by our most senior colleague and mentor here, the State Council of Zambia, Mr. Stephen Lungu. If you are with us, may I invite you or pass the mic to you. I believe you have listened to what the mentees have done, and they will be very happy to hear your inputs as to what they have done well and what they need to do better.
Thank you very much. Good evening, everybody. It's a pleasure participating and being part of this group. I think to begin with, I must say that I've learned from the presentations that have been made. The presentations were so good that I was learning all over again my understanding of what mediation is. So in other words, both the two presenters did a very good job. So the work that was done by Group 1 and Group 2 was excellent. And I think for Group 2, the one who made the presentation did the presentation at the last minute, meaning the knowledge that she's got in terms of what she was presenting was very, very good. You ought to be commended because you were thrown in the deep end and you managed to show us that you are actually a mediator, somebody who understands the process of mediation. As I said, the presentations were excellent. The one thing that I noticed is maybe it's the manner in which the questions were given to make the presentation. When we're talking about mediation, it's always good to start from the beginning to the very end. So when we're making the presentation, we present it stage by stage. The presentation started with group one started with the settlement, and then went into another presentation, and then went into another presentation. When the settlement presentation could have come at the very end, start off with a pre-mediation, move to appointing of a mediator, the mediation process, and then the settlement. But as I said, as far as I'm concerned, for somebody that understands mediation, the presentation was good. You identified the issues that needed to be communicated. There are certain terms, certain issues that are more important in mediation. You managed to identify them. You managed to explain mediation in relation to the act, which is very good because mediation does not exist in a vacuum. At least it's recognized by law, which is excellent. And therefore the presentation was flowing. When it came to career in mediation, the explanation was also very good because it showed that mediation just does not exist, but mediation exists for the purposes of people, and people can have careers in mediation. The presentation on the various modes of mediation was very good, though I must say at a particular point, I felt that your presentation was a bit too fast. Maybe it's because of time, but you're presenting it a little bit too fast. But it is also good to indicate, and as you showed, that mediation is not just one, but mediation exists in various fields, meaning you can mediate in various aspects of life. You would find mediation. The most important thing, therefore, is that mediation lives with us. Mediation lives with us on a daily basis. And therefore, people can afford to mediate in whichever platform they exist, be it insurance, in the community, be it in commercial, So all these areas you are able to ably explain. These would be my views. And as I said, I was a student. I learned from the experts that did the presentation today. Thank you so much.
Thank you so much, Leonard Silk, for giving us your perspective and your contribution in respect of this. We are most grateful. Thank you so much for that. We look forward to a very interesting session, even next week. But in the meantime, you may be called upon to answer some of the questions that the mentees may have. But let us take the contributions from the mentors, and then we'll get back to you. Thank you so much, sir. All right. So having said, let me call on Mr. Achi. Is Mr. Achi with us?
Yes, I am.
Okay. If you have something to share with us concerning the
Yeah,
presentation.
thank you for the opportunity to be part of this great movement. It's really been quite refreshing, just like the senior advocate had mentioned earlier. For me as well, it was quite refreshing listening to the presentations of Group 1 and then Group 2. Some of the things I've learned as during my training, were quite reiterated, and I enjoy every bit of it. I believe that the training will equip both the mentees and the mentors as we advocate and as we implement the principle of ADR. Now, just to make a quick input on my view, for the career prospects in ADR, there's a particular one I am aware of, which is mostly found in the educational sector. There is an attempt to address grievances. So there is this in the Ministry of Education, they have these officers that are called grievance redress mechanism, just to add to the fact that our mentees can as well consider the possibility of looking at that career prospect. I believe some of them are still maybe in their legal training. So right in the school setting, there are quite a number of conflicts that they can, of course, attempt to begin to try out their skills in settling such disputes. They can volunteer in, getting their skill tested. So that's for the career prospect. And another thing I want to make during their presentation, one did mention that ADR is a business. So I advise that let's also get to know how do we cost. When people come and we render services, we need to know how to bill them. Since it's a business, we need to be familiar of that. When this first presenter was talking about draft, I was wondering, a mediator need to, just like a mediator is serving at the middle, so a mediator need to learn how to write. A mediator need to write as much as he or she can. That is the information that will add up to all the agreement, the settlement, and all of that. So advise that ability to write, ability to put down what is happening, both the verbal and the non-verbal clues, because a mediator has to be a very good, competent communicator, ability to listen, ability to pick up things that are not said, so that we can arrive at a good judgment. So that being said, again, I enjoyed the presentation today. I look forward for more interaction and engagement. Thank you.
Thank you so much, Mr. Achi, for that wonderful contribution. Let me call on Queen Esther. Do you have something to say? In respect of the mentee's presentation?
Hello, good evening, everyone.
Hello, good evening.
Yeah, good evening, mentees. Good evening, other mentors here present. Please, kindly give me 5 minutes. Let me put what I've jotted together. Thank you.
All right, so we have also here Deborah, Maida, Maigari. You have listened to the mentee's presentation, conversation. Please, do you have something to say in respect of that?
Good evening, everyone. Good evening, sir. Yeah, I would love to start from where Mr. Achi left it. He spoke about the GRM, grievance redress mechanism, and the Ministry of Education. Okay, so I do not know if
for us to see you. I am just wondering. It seems I can't see any of the mentors who presented. I didn't see. I don't know whether it is from my end.
I just walked in from work. I don't think you'll be able to see me. Light is not clear, but then let me try.
All right, so go ahead and go ahead while you okay.
May not be so clear, however. Sorry. Okay, so what happened to the lights? Okay. I followed through the teaching, the presentations. Well done to all the mentees. As always, you never cease to amaze us when you do present. It's always a joy to hear you. And I'm always saying, I hope it is not just a presentation. I'm hoping that you're trying to make life out of what you are presenting. You see, we keep learning because it's something we are currently involved in and we are passionately deep-necked into. And so every time we hear about it, it hits back. But tonight, I was hoping to hear about career opportunities. I don't know if my network went off at the point of that particular presentation, but I kept waiting to hear what was going to be said in that regard. But rather I heard the process of mediation being repeated today. So I'm asking because I wasn't sure I heard it. She said her line kept going off at some point. So I wasn't sure if that was presented. If it wasn't, that's why I said I wanted to start from where Sir Achi left it. I was glad to hear him talk about the career opportunities that are available in the Ministry of Education. I'm personally currently following up on that. And I found that is one area that the ministry, not just education, all ministries that perhaps need to actually look into. So I won't go over what was really presented because I can see some of them in the paper presentations too. But then I would just love to add that the world and the system we live in now honestly need varied forms of mediation to come into place. So beyond paper, beyond presentation, it's time to take it out there, to begin to sell ourselves, to begin to talk about mediation, even in little day-to-day situations. Apply it to yourself with your friends, apply it to yourself and your family members, apply it within your workplace, your colleagues of whatever level, apply it in church, apply it in the mosques, apply it anywhere that there are disputes. We want to help people see that there's an alternative way indeed that they can resolve their conflicts without needing to go loggerheads. And it's cost effective, as we said. It beats time, it restores relationship of all sorts. It restores. I remember handling a case. The first case I handled this year, it ended with these two friends taking themselves for an outing. That's how effective it was. They were not able to talk to themselves for months. They've just been hissing and, just giving themselves attitude. But while we sat to mediate, I found that they were very good friends, very good friends. But there was a miscommunication between them. Do you know that they ended up agreeing to take themselves out to reconcile things? So we came to sit over their matter, but they reconciled it by themselves, sitting down on the table. And everybody was able to talk about what it was that was the issue. And we pointed out this was where you got it wrong, this was. There's always that thin line most of the time that is missed, that causes a miscommunication, a misunderstanding, or whatever the miss might be. So it's good to always find it, knowing that we are different people, temperament different, expression levels are different, but just to create room and make room for ourselves to be in it. So beyond these levels that look very okay and common, we could take them up as we grow up the ladder. Thank you for tonight. I have also learned and gained. Then thank you. I think I'll stop here. When I remember any other thing, I would add up. There were more, but I can't remember the remaining, honestly. But I'll come back.
I thank you so much, um, thank you so much, Deborah, for your contribution. So let's take His Honor, Honorable Joshua Zaka.
Oh, did you hear me at all?
Yes, we had you. Thank you so much
Okay.
for your
Okay.
contribution.
All right.
Yes,
Thank
thank
you.
you.
I'll put that
Yes.
later perhaps.
All right. So I call on uh, Mr. Joshua. If it's all right. Thank you, Your Honor, for joining us.
Can you hear me? Can you all
Yes,
hear
we
me? Good
can,
evening,
sir.
everyone.
Very
All
well,
right.
sir.
So sorry for joining late. I was caught up with another commitment elsewhere. I'm so sorry about that. Um, since I came in late, I wouldn't pretend as if I got all the uh, presentation. But I will also just want to say that looking at the topic, it's a very apt one. It tries to explain how to navigate mediation when we are out there for the mentees. For me, I want to just use myself as an example, how I go about my own way of doing things. Like I had a mediation that I did, I think I mentioned it last Wednesday when the session was going on here. And I explained, uh, I just, there was this lady, a member of my church, who had an issue and they dragged themselves to the court, and then from there they were referred to the multi-door courthouse. The matter was there at the multi-door courthouse. Now, the matter was between her and a neighbor who eventually bought a property of theirs. Now, I met him at the multi-door courthouse, and then we got talking, and he thought I was in the matter. So I said I'm not aware of what the whole matter is all. The matter is all about. So anyway, we got back home. So I now suggested. I said, why don't I? What do you think if I come in to try to settle the two of you? Um, will you want that? He gladly accepted. And when I spoke to the lady, she also accepted. Now we then went into the mediation session, and we had about 2 sessions. In fact, the first session, by the second session, they were able to settle. But there was a little hitch. When we finished the settlement, she insisted that she wanted to talk to her husband's uncle. Her husband is late, and she wanted to talk to the uncle so that it will not look as if when she decided to go in for mediation, um, she sidelined him. So what I'm just trying to say is that there is a way we can sell ourselves out there when we go in for when we start practice for the mentees. There's a way you can sell yourself out there. There's a way it can start like Deborah said. We start with our local assemblies, we start with the mosque, we start with school, because mediation is needed everywhere. And somebody asked a question, I remember last week, he said, must you be certified before you become a mediator? And I like the way Mr. Nanchan gave the answer. Yes, there is a formal mediation, a formal setting. There is also the informal. Now, all of us are involved in the informal one way or the other. But for the formal is what we need the certification for. And it is the formal now that we're talking about, you selling yourself as career opportunities and all those things like that. So it starts, of course, from here. And then there are certain things that the books will not teach you. You just have to be creative about them. See how you can sell yourself out there, talk to people. I remember saying that for mediators, or for the ADR practitioners, it has to become a part and parcel of you. One, there must be a passion. Two, there must be opportunity to let people know what you do at um, every given opportunity. So you sell yourself, you talk to people. Now, again, like in my local assembly, what I did when the Kaduna State Multi-Door Courthouse was preparing for the settlement week, I took the flyers, went to my church, explained it to my pastor over and over. He got the check. They gave me enough time in the church to emphasize, to explain to people, not once, not twice. Now, even after the settlement week was over, people come to me, talk to me about issues, and you won't just handle it, carelessly, or you just tell them, okay, you try to settle. No, there's a way you can go about it in a professional way. Let them understand that yes, you are opting not to go to court, but for mediation, the mediator also needs to have his fees and all that. So you explain the two options. But look, if you go for litigation, this and this are the disadvantages, and if you come for mediation, this and this are the advantages and all that. So you see, they want to go for mediation. Now, when you do the mediation or when you're done, all you just need to do is to take steps to make sure you go. First thing first, do all the things that your background check. What do you call it again? Make sure they submit for the mediation, and once you're able to reach settlement, you take it to the multi-door courthouse within your locality so that it will be adopted as a settlement for the multi-door courthouse there. So, and then of course the multi-door courthouse has to be your what's the point? What's the word now? It's you have to be regular. If there's a word like that. You have to be to be known there. It's that you can start from volunteering, be an intern, and all that. So there's a whole range of opportunities out there, but of course you need to what's the word now? You need to position yourself very well, and then get in touch with people who have gone ahead of you. Is very, very important. It's very, very important. I mentioned to us last week, we are all mentees in one way or the other. So you get involved. You have to be intentional about it. Talk to people, relate with people, and all that. So like I began saying, I wasn't there at the beginning when the presentations were made, but looking at the topic for today, I think this is the much I can offer as a word of counsel, and then hoping to see all of us out there one day to collaborating and doing our thing. Thank you so much for the time. Thank you for the privilege, Mr. Nanchan. I really, really appreciate. Thank you to all the mentors. I really appreciate your contributions, and to all the mentees, please keep the flame burning. Thank you so much. God bless you.
All right, thank you so much, Your Honor, Buzaka, for that wonderful contribution. Let me call my friend from Rwanda, Mispa. If you are here with us.
Thank you very much, Nacha. And hello to everyone in the house and my colleagues who have spoken, from Senior Counsel to Achille and Joseph and all. Honestly, I am really impressed by what our mentees do every day. But I think Deborah, no, is it Deborah or one of our colleagues said something? They should not just do the theory or the academics about it, but try to practice it. And the new career opportunities that have been raised, and just the way Honorable presented, or Your Honor presented his own practice experience, how he market himself, how he creates visibility around his practice, is very important. I really enjoyed it. That's what we can call a micro way of marketing yourself, which is really, really very important. So you people, an approach can work for one as well as can work for two. So just try it. If it works, fine. If it doesn't work, just keep pushing, never give up. You might not have to be on the stage to sell yourself, to market yourself. You can start from your church, just like every other one said. And just to tell you again about the GRM, that nowadays, if we don't approach, you do what we call concept notes. You can do approach these ministries or schools such that you can educate them, let them understand the benefit. Why mediation? Okay, some schools will call it a grievance redress mechanism. Some other schools will call it, some other schools will call it peace educators. So these are new doors or windows that are opening for young early careers professionals like you people and even us. But if you want to really brand yourself microly, it's good to start from that end. Somebody will not need too much of accreditation for you to do that. But when you start going into commercial mediation, business mediation, family mediation, people want, or insurance mediation, which people are not really paying attention to, but it is something that is really, really sought for. Because talk about accidents that occur. How will you resolve that by litigation? Excuse me, I have cold. How will you resolve that by litigation, if not mediation? That's why you see there are a lot of insurance case pending in court, pending under litigation, because litigation may not be sufficient. Imagine where, yes, you've murdered somebody, litigation will tag and charge you for murder. But with mediation, you can never pay life, but at least you can compensate. You can make parties reach to a reasonable settlement or compensation. You understand? But with litigation will sanction just the law as it is and not as it ought to be. Give you life imprisonment, whether it is a manslaughter or it is a murder or it is a battery, whatever it is. And then, but with mediation, we can redress this and you can even get some compensation. Yes, you cannot pay for life, but as well, you don't go again empty-handed. You gain nothing for that person being in jail, or his life is not going to bring back your person that was knocked down by a transportation company. So these are areas we really need to work on as young people coming up. Another one career area that you didn't mention, you people did not mention, is publication. Scholars, academians. Mediation is, in as much as it is archaic and traditional, but they are still on, untapped areas in research, in publications that have not been done. And this is opportunity for you people to start looking at it at the level of academic, to write articles, write books, publish journals about these mediations. And you can even do a kind of a mediation pitch where you even conduct some interviews, some podcasts from practitioners, share their experiences, put it down into a book, and you write it, and this becomes commercial for you. That's opportunity. Okay, these are opportunities to make money as a mediator. But let's look at, there are some key things that, especially for senior counsel from Zambia, spoke about the order, the way the presentations were made. But I understood because I was there from the beginning. It seems like group 1 was not ready and group 2 had to present first. That is the reason for them starting with the settlement terms. Settlement terms is the life of mediation. A settlement agreement is the life of mediation, what you arrive at. And for you to be able to arrive at, there are very key things that I personally consider, and I encourage you to consider as a young practitioner. First and foremost, before you go to that mediation, you already have the details of the case. So why not set a clear objective first? That's what I do. I set a clear objective. What are we going to achieve? What are the needs? I try to understand the needs of both parties. Should I identify primary interest and then the objectives? So these thoughts run through your mind as a mediator. You have to give priority. Make a distinction between these issues Okay, the essential issues and the ones that are less critical to you can bring them to the latter stage of the conversation or the negotiation. Make sure that you have an open conversation where we know our tools of active listening and expression of emotions comes in. Okay, sometimes, especially when you're doing family mediation, employment, because employment mediations are very, very emotional too, sometimes, just like give people the room, allow them. I've seen mediators where somebody wants to explain, he's trying to cut it and stop them. No, allow them. The more people pour it out, they pour out their grievance from the pain of their stomach. That's how they get to heal faster. That's at a settlement agreement or a settlement condition. Okay, so allow that space for them to express their emotion. If they want to cry, in some I saw in the UK, I went to there is a mediation center. I went. This is private. They have even a jacuzzi in their bathroom where you can even go and take a shower, go and let water pour around your head. Some is a pillow. If you know the best way to relieve your stress or is to cry out, and sometimes you can't cry because maybe neighbor noise nuisance, and you get there. So pillows, they give you a pillow to cry out if you want to cry, or scream it inside if you want to scream. So there are different tools and mechanisms that you can give people to allow them to express their emotions. And then trust, which is something that is inevitable, rapport. Always try that in your practice, you build trust amongst your colleagues, trust among your parties, trust even in the procedure. You should be able to structure yourself as a trustworthy person. Be confidential, which is very key. We say this all the time, but I tell you, some people, their mouths run like water. Some people's mouths run like water, and this will destroy your career, your practice. Conduct a kind of a respectful interaction. This is always key. We always say this during when we are setting the ground rules. Ensure that interactions are respectful and not the one that is insulsive. It can be aggressive sometimes, but not physical aggression. But words people can throw, express anger, emotion, but let it not become physical. I've seen some colleagues have said parties almost fought with them in mediation. So different things happen. So you should be able to face these things. But because it's not like litigation where there is a police standing there, if you do commit a contempt as the judge might even say, counsel, to the dock. They send you to the dock and they unwick you, they unwrap you, you enter the dock for sanction, or you are being fined for contempt. But this is different with mediation. So you have to really know how to manage these things. Fairness, do your best to be fair. And also, there is a follow-up mechanism. This is something that we fail to. There is a follow-up mechanism in mediation, okay? And what do I do in my follow-up mechanism is I set an implementation plan. Because when we leave that room, what next? To make it different, to make your practice different, set up an implementation plan. Okay, and then you give credibility and value to mediation as a dispute mechanism. Don't just resolve there and you disappear. It's gone, or you are not able to reach a set. You just disappear. So create a detailed plan for how the agreement will be put into action. Also set a monitoring progress plan where the parties will all sign. They will agree to it and they will sign it. Okay, so you spoke about pre-mediation meetings, which I took some points down. Before pre-mediation, you can meet parties individually. Okay, it is allowed. You can meet parties individually in as much as you had already received files or the bundles from each party. You can meet them individually before you have a joint session. So each party to prepare. You are trying to get an understanding of them, not. Remember, maintain your independence and your neutrality, but try to get an understanding, try to get parties' position. This helps the mediator to even resolve some issues before you come to the joint table, okay? And this helps you when you are setting the agenda, you make it very clear. Then when we talk about, you talk about facilitation skills, when you are even facilitating under facilitative mediation, you have to be very neutral. You have to use conflict resolution techniques, which is somewhat of reframing the issue, reframing parties' position, and presenting it to them in a summary for them to be able to and arriving at a solution. My dear, the profession is very big, open, but like I said before, yeah, your independence is key, your professionalism is key. I encourage us to continue learning. Myself here, I continue today. Presently, I'm on one cohort when we are still learning ADR under the Asian mediation and the Singapore Convention. We keep learning every day. Make sure you maintain your network with peers, whether with us, your mentors. Join mediation forums or groups, share your experience. When you see some of our posts, when you see your mentor's post on LinkedIn or somewhere, go and comment, express yourself. That's how you get that visibility. Let me tell you something. We have different portfolio in the society, in the market, in the industry. By the time, just because you might come under my LinkedIn post, you make a comment under my LinkedIn post, and then you tag me, a mentor, you maybe share a thought of something that we had today in this our mentorship program of this today, Wednesday. Look, the belief my own ecosystem have about me, that's how they expect. That's the perception they have. They believe that this mentee will not be different from the mentor. So this mentee has characteristics of the mentor. So this is very important. Reputation and perception is key. Mediation is a dynamic process. Like I said, it requires you to blend your communication skills. My other colleagues have said this, blend your communication skills with your strategic thinking. And then you put emotional intelligence. I spoke about this emotional intelligence last week, Wednesday. And then you make your practice a very significant and effective one as a mediator. Thank you all very much. We look forward and keep from you. Thank you.
Thank you so much, Ms. Pam, for that wonderful contribution. Now, so having said so, let me call on Zubaida. Let me call on Khadija. After which Esther will come up with what she has. Then we take questions.
Good evening to you all. And I'm happy to be back. Hope you are all with me.
No, we are not seeing you.
So do you really want to see me? I'm very excited today about the topics, and they really did a job well done. But with regards to the drafting, the key point that I want to include here is that you should know that when drafting the terms of settlement, you should try as much as possible to make it to be clear and precise, and also unambiguous. What I mean here is that when drafting the terms of settlement in mediation, ensure that with due respect to all the lawyers here, that we don't use all those legal terms, herein, after, therein. If it's a boy, it should be so precise and clear that you mean a boy. Do you get me? That so that wherever your terms of settlement might land, when one is reading, it should be so clear and straightforward to the point. Then with regard to the issue of confidentiality from the end of the mediator, confidentiality will end. Sometimes when, let's say for an example, you went into a private sessions with the parties, that is what we call caucusing. That private sessions are called caucusing. If you go into caucusing with them, and then they kept, but you see, parties will have that confidence that you want the parties to have with you. It's from that caucusing. It's from that caucusing that you'll be able to sieve out. You'll be able to understand the the underlying interests. Let me give you an example. For example, there is party A and party B, and party B might come in saying it's my 10,000 naira that he has to pay me, and he promised to pay me since the last 2 months, but he has refused to do that. You by mere seeing, because you know to understand them, not only from the word, you should be able to sieve out the underlying interest, their underlying interest. You'll see that by mere seeing of your party, you know that, haba, this one has passed that one, what is it called, that 10,000 naira that he's talking of. So there is something deep down. So when he is assured of that confidentiality, he would open up, and you might end up finding out that he just need the other party to, to accept that what he did to him was wrong by him not paying him on that particular time that was agreed, and him accepting that fact and even apologizing. From that part, you will see the party saying that, okay, it's better, and they are able to settle, and that was all that they were, they are looking forward to, not actually what they came in for. A party might said, I come in to get that my 10,000 naira back. That is the issue. But when you get to talk more with them in confidence, you might get to know that it's not about that 10,000 about is his plan, unless with the with the approval of that party. You have to ask that party that, okay, can you discuss so with the other party? So if he said yes, you might go ahead and do that. And you should know that under the principle of confidentiality will end where there is illegality. What I mean here is that while one party in confidence, you're discussing, and he now opened up to you to something that is illegal. Let's say, for an example, that Hajia, we are planning to kidnap so and so, and all those illegal issues, they are coming in with arms and ammunition and all the illegalities. You should know that you, as a competent mediator, are not supposed to hold that in confidence. So you see, even the rule of confidentiality has some limitations at times. So you should, and I also want to touch on the issue of you as the mediator, as a competent mediator. You know that a lot is expected from the mediator. Let's say the issue of neutrality, you being so neutral, is sometimes very tricky, because you dealing with two parties, and let's say, for an example, and now I'm speaking with party A, and I will be like, party A will give me, as he's narrating his story, he will be like, and my husband gave me a dirty slap, and I will be like, what? So I want you, why are you seeing my reactions? Are you with me, class? Are you with me?
Yes, ma'am.
Okay. So you see, let's say communication. What I want you to understand is, you being neutral is not only while communicating to them or how you act. You should know that it includes both your, what is it called, verbal and non-verbal communications. In short, your tonations. the way your tonations also matters in how you communicate. Let's say you communicate with party A and your tonations were a little bit down, and when speaking with party B, you would be like, you're saying, let's say, for example, that I'm telling you that he's gisting me about, okay, he's telling a story about how his husband, all those domestic violence issue, and like all the facial expressions are out. So you'll see you are like, as you are like given the other party and what is it called, insight, that you are believing in what that party is saying to you 100%. So ensure that if you are going to make all those gestures, all those body movements, and not only communicating normally, but also raising your vocals, ensure that you do that to the other party. So in order for them to really, really know that you meant you being neutral and not taking any side. You should also know that as that mediator and as a competent mediator that you are, it starts from how you welcome them in and the seats you give them. Don't say that, let's say, since this is the chief, a chief in our town, and this is just a common man here, so he takes the softer chair and you give the other wooden chair to the other party. So you should know that in mediation, when we say treating the parties equally and neutrally, we really mean it from the scratch, from how you greet them, from what you usher for them to take as drinks, and from the seating arrangements, from how you speak to one and the other, from the nodding you do to the other side. You ensure you also equalize it to the other side, and also ensure that you are being soft on the parties but hard on the problem. So don't look much more at don't consider, let's say, if one party is being not looking so nice at you. So don't be like, since this party came in, he's in an angry stage and he did not even greet me properly. You should be able to understand that his feelings. That's why I said the last class that you should be able to empathize but not sympathize with your parties. That you should be able to. So I think, and it's okay. Thank you very much. Thank you for this opportunity, and we've learned from each other. Thank you. Have a nice day.
Thank you so much, Khadija, for that wonderful presentation. Quickly, let me call Queen Esther. Queen Esther.
Good evening, everyone. Please, I hope I'm audible enough. Good evening, mentees. Good evening, fellow mentors.
We can't see you. Yeah.
Okay, sorry, I may not be able to put on my camera now because of the environment. So I've gone through all the slides and listened to the various contributors of the mentees, of the mentors and even the mentees. And I will say, first of all, congratulations. It's been 2 awesome weeks of learning, unlearning, and relearning. It's been amazing. And these are truths that are there to build us up, talking to the mentees right now. These are truths that it's not just something we should just hear and it should end here. It's something that we should run life with, especially if you want to build career in the aspect of ADR and mediation in particular. So having listened to all that has been said, I just want to hit on one key thing that will actually make us delve into some other things, and that is the matter of competence. Now, competence refers to the wide range, the wide array of all the skills, the attitude, and your experience. It is your competence as a mediator that will inspire confidence in the parties, the process, the profession, and even the general public at large. Now, when I say it involves the arrays of skills that you need as a mediator, I'm talking about the principles of mediation. How well are you conversant with it? How well are they at your fingertips? Yes, a lot of people, mentors have actually laid emphasis on some of these principles, the principle of confidentiality, impartiality, and a lot more. But I'm saying that it is not enough to know about impartiality. It's how deep are you into this principle? How well do you have them at your fingertips? And that is where your competence lies as a mediator. That is where your competence lies. Still, competence also is what we to build competence with what will make you to learn more about the problem-solving skill, how to ask questions. It will push you more to know how to really use this question, because as a mediator, you're a facilitated negotiator, right? So if you will not settle for mediocrity, it is a continuous learning process. I think I'll take it that way. It's a continuous learning process. So at every point in time, you are learning, you are attending seminars, you are attending webinars to build yourself, to hone your skills. Because you will feel like, oh, you will learn something in this mediation class today. You will be surprised that you will also go for another mediation class. And wow, these things are coming, not necessarily new, but they are coming in a fresh way. And seeing how you can also deploy it. Especially how to analyze conflict as a mediator. How to analyze conflict. These are key things. And again, as a mediator, now I'm talking about competence, and I'll be touching on several areas that should really, really major on as a mediator, which will actually entails the principles of mediation. It's also how we set our agendas in mediation. And then that will give you the roadmap to follow. Remember, sometimes when parties come to the mediation table, some of them may want to just be talking up and down. Sometimes the parties come, they don't even know what they want. Honestly, they just know they have issue. So it is you now, when you build competence, when you hone your skills, the principles of mediation and all that, they'll be able to narrow the issue, help the parties to truly identify what they want. Help them identify what they want. So that is it. As a mediator, we should build competence, our listening skill, because mediators are good listeners, our negotiation skill, our questioning skill, very important, because the best way to break impasse, deadlock, the best way to help them is when you are able to ask questions. It's when you're able to ask questions that will bring them to actually bring out what the issue really is. Because most times these people don't even know what they want. It's very funny. They have the issue, but they are the ones that don't even know what they want. And that is just it. And please, let's never forget that dispute come as a result of misunderstanding. So it is your questioning skills that will actually break through. Just like through your questioning, you are clearing the road to really get into the root of the matter. And you can only do this when you are competent, when you are a competent mediator. Same, it is your competence again, like I said from the beginning, it is what will build confidence in the party. You have to have these rules, these principles at your fingertips. And all this thing begins with your word, opening statement. And so I'll say it again. I'm sure they've said it several times here. Take your opening statement very, very serious. From your opening statement alone, let me tell you, these parties will size you if you know what you are doing or not. And that's why with everything in you as a mediator, treasure your opening statement. That is your selling point. That is your selling point. And again, on the final note, before actually cut the curtain here or draw is the fact that for the mediation process, the preparation, which entails your opening statement and all, the confirmation, the party's opening statement, how you guide them, the negotiation itself, all these matter. When I say the preparation, it's talking about the venue. I'm sure maybe someone have said it before. And all this thing boils down to competence. Is it well lightened? Is there proper ventilation? The sitting posture. All this. The bedrock of all these things is we've heard so much. But let it not just be that we heard it, but that in all that we've heard, we are intentional about being the best in those areas, in those things we've mentioned. Oh, there is this principle called confidentiality. Oh, as a food mediator, I should be a good listener. Go take more courses on emotional intelligence. Like I said, I'm talking about competent and it courses across several areas. I remember I had to take courses on emotional intelligence several times. People's temperaments, how do they think? All of this, it's what helps you to be able to navigate this first set of mediation properly. It should just be like you've gotten the magic over it all. And on the final thing I want to say is that not all mediation process or section end up in settlement. There are times that people don't settle, don't figure out that, oh, you're not able to, this one did not settle. No. Sometimes people may not settle, but the goal is you as a mediator, you've done your part. You've gotten the parties to communicate their mind. The fulfillment comes when you knew or you know that you did your part to the best of your ability. So once again, I want to say congratulations to everyone who was able to participate in this mentorship section. It has been, I've also learned, you learn this thing, also refresh your memory, and it has been a wonderful experience for me as well. I want to say a very big thank you to Mr. Nanchan. I want to say a big thank you to JIIPCC. Thank you so much for the opportunity. God bless you all. I want to see you all at the top at the table of mediation. Thank you so much.
All right. Thank you so much, Queen Esther. Queen Esther is one of the youngest mentor in the house, and it's not by mistake. She emerged as one of the best graduating students during her set, and she has been keeping the flag running. Thank you so much for creating time out of your busy schedule and out of your studies. For you to know that Queen Esther is also a student in Ahmadu Bello University, think of a final year student, and she took the course with Settlement House Idea Training Institute, and she is now a certified mediator. And she has been keeping the flag running. We are trusting that we'll have more people who will be passionate like that to be able to contribute to the ADR space, both within the students and those outside. Thank you so much for that. Now, without waste of time, I will want to call on one of our cherished mentor. I believe everyone has spoken, unless, yes. Okay, so let me call on Mr. President. I deliberately allow him to speak at this point because he will be able to tie up some of the things, including some of the major things we are supposed to learn in the things we set out to achieve in week 2 of the JIIPCC Shadi mentorship program. Mr. President, sir, may I have the singular honor of inviting you and passing the mic over to you, sir.
Thank you so much, Nanchan. Pardon me, I have power cut, so it doesn't usually happen. But tonight I have power cut, so I'm unable to show my video. If I show, I'm already dark, so I'll be more darker. So thank you for the opportunity, and let me say hello to all the mentors. They've done great work in teasing out what the mentees have presented, and also to congratulate the mentees on their work, their well-researched work, and the presentation that they did. I think the mentors have already touched on majority of the important point that they have to take key note of. Particularly the first person mentioned that yes, the structure. If you are talking about mediation, you don't go and start from the end product, the byproduct or the end product of mediation, which is terms of settlement. So in order to put it in a proper perspective, so the mentees are supposed to take note that for mediation to start, when they were talking about ADR clause. So when you are talking about ADR clause is general. So it can be an arbitration clause, or it can be a mediation clause, or it can be a negotiation clause. So what is important for you to note is that what clause are you talking about? It should be specific about the clause, whether it is a mediation clause. So if it is a mediation clause, is it in a contract? Is it in a separate agreement? Or is it in an exchange of email, or what kind of electronic communication between the parties that keeps record that they have an agreement to mediate in the event of a dispute between them? Then mediation also can be initiated without even any agreement to mediate. So that is the basic understanding you have to know, is that majority of laws across the world allows for parties to go for or to initiate mediation process when they don't even have um, any mediation clause in their contract, or they don't have any mediation agreement to mediate. So if they don't have that, what will happen is that one party will initiate, the other party must also give consent to mediation. So the other party must also consent to the mediation. So when you mention agreement to mediate, there are two main types of agreement to mediate. So first one will be an agreement which is the consent, an agreement to say that yes, we have accepted to go through mediation process. Then there will be another agreement at the end of the process if the parties are able to build consensus around the issue. So that becomes the agreement. So if you are, that is why sometimes, in order not to confuse people, we don't normally even call it a mediation agreement. So we normally refer to them as consent to mediate, and the latter part becomes the terms of settlement. So structuring what you did, so I would say that number one, we'll start from drafting the terms or the clause, the mediation clause. What kind of clause are you putting in your contract? It all boils down to how the relationship start and what you envisage the conflict can be, and how you want to keep that with mediation. So you draft a clause in which serves as a prior agreement in your contract to cater for that particular issue. So when you're able to have that mediation clause in your contract, that is the first point, of course. So then after the issue has happened, still, although it can be an agreement in a contract, but still, once you initiate the process, the other party must also still consent that indeed they want to go through the mediation process. And because mediation or ADR processes are party driven, parties has autonomy over the process, and mediation can be mandatory, but you cannot force the party to go through the mediation process. So you still need the consent of the other party to make sure that you are able to build consensus around the issue. So when you're able to get the consent to mediate, then The consent to mediate can be obtained whether exchange of letters, emails, or at what we call the pre-mediation level, where the parties can meet, or the mediator can decide to do different meetings with the parties and have their consent before bringing the two parties together. Or sometimes even the at the pre-mediation stage, it depends on the nature of the mediation. If it is an institutional one, it is the institution that will discuss all these matters with the parties and even assist the parties to select or appoint a mediator. Or the parties may also decide to waive their rights and give it to another institution or another individual or whoever that they cherish or they wish to appoint a mediator for them to go through the process. So once that is done, once a mediator is appointed, then the mediator will now meet the parties. Then the mediator will now prepare the parties. That is what we call the mediator giving him or herself the opening statement, your opening statement, to prepare the parties for the ultimate process. So that is where the process comes in. So you were talking about procedure. So it comes in, the procedure comes in. Then if the procedure or the process is successful, then it can yield a result, and the result becomes the outcome. The outcome is called the terms of settlement. So within the process too, I think the second presenter who did the careers in ADR was talking about the mediation process, and he was trying to mention caucusing. I think he couldn't bring it out properly. Caucusing can happen in the mediation process within the procedure when you feel that the parties are having impasses and there is a need to reduce the impasse, reduce or to meet the other parties separately, where the parties will be able to disclose certain information that they may not be able to share during the joint session. It is important to do what we call caucusing, having private meetings with the parties. It is within the procedure. So at the end of the day, you have your terms of settlement, which is the outcome. So in drafting the terms of settlement, I think I jotted some points down. It is important to be specific about it. So if you are saying that the party agreed to pay the outstanding balance, that is what I saw in your presentation. What is the outstanding balance? How much is it? How much was the outstanding balance that the party decided to pay? It is important to be specific because your outcome of mediation can be a basis for another conflict, because at the end of the day, if you go back to the understand or the undertaking that you have done, the outcome that you have done and signed, and it doesn't talk about the outstanding amount, then what amount is the person expected to pay? So you should be specific and be able to do that. Then you were talking about introduction. Sometimes we call it the preamble. The preamble, you are giving maybe some few overview about what the issues were, and the parties decided to use mediation to resolve it, and they have been able to use mediation, and mediation has been successful. That is fine, and good. But one thing I also note from your draft is also that the payment, he said the payment will be made. When will the payment will be made? On what date? And what are the timelines? Is the person going to pay all the amount in full, or they are going to pay it by installment? And if by installment, what kind of installment? How will the money be paid? And who will monitor that the money has been paid? It is important to take note of all these things, because these are documents that you prepare that can end up in the court. Because don't forget that once you are drafting a terms of settlement becomes a legal document that can land in court for the purpose of enforcement, and maybe for the purpose of the parties also disagreeing with the terms in the agreement. Then Someone also mentioned about appropriate appointing authority. So the mediator will be appointed by the appropriate appointing authority. What is the appropriate appointing authority? So that is why you have to be specific. If you are talking about that institution, if you are talking about Shati, if you are talking about this, if you are talking about that institution, not appropriate institution. If you are talking about the party will waive their right to an appointing institution, what kind of appointing institution? If it is in the agreement, if it is agreement to mediate, and you are saying that you waive your right to the institution that will manage, or the parties will agree to manage the process, that is fine. But if you have already designed the process and you are saying that an appropriate appointing authority will be made to appoint the mediator, then it becomes problematic, because which one is appropriate and which one is not appropriate. So we have to be specific in our drafting. So it is important for us to take note of these things. And also, when it comes to careers in mediation, as other mentors have said, there are wide range of mediation, and even now with the evolution of technology, with AI, with videos, with TikTok and other things, with YouTube and all that, you can take advantage of it, where your platform will be about educating people on what mediation is about, what they can do with mediation, how mediation will be useful to their business, to their home, to their church, to everywhere that they find themselves, and being able to talk about them and express them. Based on that, you build a character around it. Mostly, we are able to understand these principles because you teach what you know. People ask you questions which challenges your thoughts, and you are able to answer them. You try to read more, do more, answer them. There are a lot of also free programs online that you can get. Some of them you may only pay for the certificate. Some of them you may not pay for the certificate. I remember there is Aripo and WIPO is doing a free webinar, a 2-day webinar on what the process is, what happened when you submit an IP dispute to WIPO. When you send it to them, what happened? They will tell you, they will teach you, they will coach you how the system, how the process is done. All these things builds capacity, so that in an event you find yourself in a similar institution, you know how to manage yourself. So don't stop learning, keep reading, keep watching videos. There are a lot of videos on YouTube and other. There are certain websites like mediate.com with important articles that will expand your knowledge. So you need to visit such website, read the articles that people have written, and evolve and become better based on the articles and the reviews that you do. As one of the mentors mentioned, post on LinkedIn, talk about it, follow people, comment about what they are saying. Based on that, you are able to expand and network. We all got to know people based on the things that we were doing on the internet, based on conferences that we were attending, based on the discussion and the forum that we attended. Based on that, we were able to create network with people from diverse backgrounds. And today, if we can have someone inviting me in Nigeria to come and share what I know with you, the same way when I need him, I can also invite him to share his thoughts with our community as well. Based on that, we can all shape the system. So the system is big. It's like having an ocean. You don't need to sink somebody's ship before your ship can also sail. So everyone can thrive. So you are welcome on board to also thrive in the mediation space. So I wish you the very best, and I want to thank the team for organizing this. Thank you so much, Danchan.
All right, so Thank you so much, Mr. Isaac, for that wonderful contribution. Briefly, we are going to just take a few questions because the processes and what we need has been clearly explained by our mentors. We appreciate them for giving out this precious time of theirs. So, do we have any question? You can raise your virtual hand or drop it on the chat. Any question? Okay. So I guess there are no questions. And let me say that, our mentors have created time to be with you. We are supposed to be quite a number, maybe about 40 or thereabout. And maybe it seems because the mentorship is offered maybe for free, maybe that's why many of us are not available to attend. That's not good at all. I believe that by next week, you will create time. You will create time. I'm hoping that next week, the mentees will actually create time and attend the meeting. I see no reason why mentors will be on call and the mentees will not. The program was specifically arranged for you. I tell you that if you have to schedule, even if it is a 30-minute consultation with any of the mentors, so to say, you are going to be paying a lot of money. But they have created their own time, created time from 6 o'clock. This is almost 8:30, 2 hour, 30 minutes. Some of them take a lot of money just to make presentation of 45 minutes, 1 hour, and then mentors are here, the mentees, some of them have left, have gone. That is not appropriate at all. I will encourage you to take advantage of the mentorship. You have opportunity to ask questions about areas that are troubling, things that you do not understand, which you cannot easily come by. Before you can get answers to some of those things, you must have attended a lot of trainings and have a lot of conversations. But all these mentors, so many of them are all there for you to ask questions and tap from their knowledge and experience, which I believe the question and answer session is supposed to take care of that so that you can ask more questions even outside of what you are discussing, because of their knowledge and expertise, they will guide you through. So I want to encourage you that when you have this kind of opportunity, you don't take it for granted. You utilize it, make the most out of it, and then you you will have us to thank later when you take advantage of it. So but in a whole, I want to appreciate all of you for creating time to attend and to make your presentation, which was very lively and wonderful. And you have talked about mediation and career opportunities. When we have opportunity, we are going to be looking at the detailed processes and stages of mediation, so that when you are doing your practicals, you'll be able to be guided. So maybe we'll look out for a session to do that. For now, thank you very much for all you do. Please ensure that you don't stop halfway. Ensure that you create time, especially when the mentors have created time out of their busy schedules to be available for you. Take advantage of it and learn what you can learn. Thank you so much. Mr. Denny, over to you.
All right, thank you so much, Mr. Nyacham, for helping us run through today's session. And we want to say a big thank you to our mentors that have also taken out their time to share with us their knowledge and experience within the lines of mediation. Thank you so much. We really, really do appreciate. For the mentees, please, we want to encourage you to take advantage of the question and answer segment to ask questions that to further help the drive home the points of the things that you have researched on and the thoughts that the mentors have shared in class. Please let's make a habit of asking questions in session. With that, I think it's safe to say that we have thoroughly dealt with mediation and the career opportunities in mediation. We've had like quite a number of mentors who have shared their thoughts and their experience with us, both in-person experience and textbook experiences that they have in relation to the topic. So thank you very much, everyone. We really, really do appreciate. With respect to this, we'll be closing the section now. Please, the mentees, do not forget, for those who are in class, do not forget to fill in your attendance, and do not forget also to share what you have learned on the different social media platforms. Tag our mentors, tag Shati, tag JIIPCC, and yeah, we'll see you all next week. We have another interesting discussion scheduled for next week. Please pay attention to the fact if you are being assigned to carry out a particular role or a particular task. Please let's get straight to it and make sure that we are all contributing equally to our responsibility. Thank you, everyone. Good night and enjoy the rest of your evening.
Okay, good
Thank
night.
you and goodbye.